We've got a hugely topical episode today. I have the incredible honor, as always, of being joined by my co-host for our series Class with JAMIE RASKIN, where the congressman debunks right-wing constitutional fallacies and fever dreams. Today's episode could not come at a more opportune moment as the Supreme Court now considers the question of presidential immunity for Donald Trump. And while there's a lot of spin out there, no one to better counter that disinformation than JAMIE Raskin. So I'll hand it over to the congressman who will take on the right-wing fallacy that as commander-in-chief, the president has both the power to do whatever he wants and absolute immunity from any legal consequences for criminal actions.
Brian, thank you so much. I'm delighted to be with everybody. Today we're taking on a fallacy that's so obvious, so glaring, and so striking. But what's interesting is that sometimes it's the most obvious fallacies that are the trickiest ones to debunk and refute. I remember Sherlock Holmes once saying that there's nothing more deceptive than an obvious fact. And that's definitely true in the age of Donald Trump, because this is a case of first impression, like so many of the other issues that are raised by Donald Trump, because no other president has acted in such extreme and explosive and incendiary ways. So it's not like there's a bunch of precedents that map out how to respond to it. And so we have to search through the Constitution to explain why his actions are completely in derogation of the constitutional fabric itself. The case that is being considered by the Supreme Court, Donald Trump's claim that he's absolutely immune, is indeed a case of first impression, just like many of the other fallacies that he has floated during this period. But what we're going to look at is this one. As commander-in-chief of the nation, the president has both the power to do whatever he wants and absolute immunity from any legal consequences for his criminal actions. Now, there are actually multiple fallacies tucked in here. I've snuck in like a law professor on a final exam. The first is as commander-in-chief of the nation, which the president is not. That is not his title. He's commander-in-chief of the Army and Navy during times of actual conflict, from Article 2 of the Constitution, and of the militias when they're called up into actual service. So any president who walks around saying, I'm the commander-in-chief, like he's the dictator of the country, is just absolutely wrong. But the central fallacies here are that the president can do whatever he wants, something that we heard repeatedly from Donald Trump when he was in president. He says, and then there's the Article 2, which allows me to do whatever I want. Of course, the central job of the president under Article 2 is to take care that the laws are faithfully executed. Not that the laws are violated or the laws are departed from, but the laws are faithfully executed. And if the president could do whatever he wants, then why do we have the power to impeach and convict the president for treason, bribery, and other high crimes and misdemeanors? And then, why do we have the power to prosecute him? Or do we? Because that's what this case is really about, that has gone up to the Supreme Court, United States versus Trump, that was found against the president in district court by Judge Chutkan, against the president by the D.C. Circuit panel, an excellent panel made up of Judges Pan, Henderson, and Childs, two Democratic nominees to the bench, one Republican nominee to the bench, but all unanimously rejecting Trump's claim. What does he say? He says a former president cannot be prosecuted criminally for anything that he did while he was in office, pursuant to his office. And again, no president has ever alleged that before, which is why it's so foreign and so strange to our experience. The judges in the D.C. Circuit do a great job of leading us through this, and I'll kind of follow their lead and embellish a little bit on several different points. But the first point I want to make is generally about the structure of the Constitution. Article 1 puts Congress in the first article for a reason, which is that we overthrew a king, we wanted to get away from monarchical government, and we wanted to vest power not in a monarch, lord, in a czar or an emperor, but in we the people. And the House of Representatives and the senators in the Senate are the representatives of the people. And we are the lawmaking branch. And if you look at the Constitution, as I hope you will see that Article 1 goes on for a long time, setting forth all of the powers that Congress has to regulate commerce among the states, to regulate commerce between America and other nations, to coin money, to govern naturalization, to govern the district that's to become the seat of government, and on and on. And then in Article 1, Section 8, Clause 18, and all other powers that are necessary and proper to the execution of the foregoing power. So it's very expansive. Then you get to Article 2, Section 3, and look at that last phrase there. This is really the core of it. It's about naming ambassadors and so on, giving a State of the Union address. He shall take care that the laws be faithfully executed, and shall commission all the officers of the United States. That's it. And then you get right into Section 4, after stating that the president shall faithfully execute the laws, setting forth how the president can be impeached. The president, VP, and all civil officers shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. But I just want you to keep that design structurally, generally in mind as we get into this issue, because Congress is put first, and the president's job under Section 2 is to take care that the laws are faithfully executed, to implement the laws of the Congress. All right. Now, Trump attempted to bypass and overthrow the Constitution of the United States when he tried to stay in office in the weeks leading up to January 6th, and then on January 6th itself. That's what this case is about. This case comes from the criminal trial of Donald Trump on 4 charges that have been brought by Special Counsel Jack Smith. The first is a conspiracy to defraud the United States of America by collecting all of these fraudulent electoral college slates from different states and then asserting that these are the bona fide, honest electors determined by the states in their presidential election, which they most assuredly were not. The second is the conspiracy to obstruct a federal proceeding. Here, the joint session of Congress called under the 12th Amendment to receive the Electoral College votes sent in by the governors through their certificates of ascertainment sent to the House and the Senate and to the Archivist of the United States. Third is actual interference with the federal proceeding. And then the fourth is violation of the voting rights of the people, a conspiracy to deprive persons of the United States of their right to vote. Okay, so those are the 4 criminal charges. Donald Trump asserts against all of them that he's absolutely immune from criminal prosecution for official acts he undertook as president. Now, one of the amusing things about that is asserting that the attempt to overthrow the presidential election was an official act. Of course, his official responsibility there was to leave office after 4 years and to take care that the laws were faithfully executed, including all of the laws passed under the Electoral College provisions in the Constitution. That's what he was supposed to do. But he was saying, no, he undertook these official acts to try to get the state legislatures to set aside the Electoral College votes by trying to get state election officials like Secretary of State Brad Raffensperger in Georgia just to find him 11,780 votes, and then by trying to get the Department of Justice to falsely declare it a corrupt and fraudulent election, and then finally by trying to get Vice President Pence to step outside of his official constitutional role, administering the counting of the Electoral College votes. The idea was to try to get Pence to force it into a contingent election, or just to go ahead and announce that Trump was president, and then Trump was prepared to ride over on the shoulders of the mob like Mussolini and come in and simply declare himself president again, and then invoke the Insurrection Act and call in the National Guard to come and put down the insurrectionary chaos that he had unleashed against us. All right, that was basically the plan. Well, he says, you can't charge me for any of these things I'm absolutely immune from criminal prosecution as a former president. Now, on behalf of Trump's argument, let's stipulate this. There are some constitutions in other countries which make former presidents immune from criminal prosecution for things like coups and insurrections. One of them, for a while anyway, was Chile, which said that Pinochet could not be prosecuted, and this was part of an arrangement they made with the new constitution. He would have immunity from criminal prosecution, very explicitly set forth in that constitution. There's a couple other examples. There's nothing like that in the US Constitution, and of course, as we'll come to see, it cuts against everything we believe about our Constitution and its entire constitutional design. So, and in fact, that common sense intuition was articulated by the Republican judge in the DC Circuit, Judge Henderson, who said that it would be a striking paradox if the one person in the country charged with taking care that the laws be faithfully executed could defy and violate the laws and then be exempt for his violation of federal criminal laws in the process. All right, so how do we go about looking at this claim? Well, Trump says, first of all, he's so immune from prosecution, it's not even up to the courts to determine whether he's immune from prosecution or not. That, of course, is ridiculous under Marbury versus Madison, the famous Supreme Court decision rendered by Chief Justice John Marshall, proclaiming the doctrine of judicial review, that the Supreme Court has the right, the power, and the duty to declare what the law is. It's emphatically the province and duty of the court to say what the law is and to sort out, precisely these kinds of conflicts. We've got Supreme Court decisions that stand for the proposition, in fact, that the Supreme Court can review presidential actions for their constitutionality. And here's a great one everybody can remember. It's called the Steele seizure case. In this case, President Truman faced a series of strikes around the country and was nervous, along with Congress, that the shutdown of the steel industry would interfere with necessary production of weaponry during the Korean War. And Congress attempted to give President Truman the power to intervene to reopen the steel plants by seizing the steel plants, taking government possession of them, and then commanding production of steel. That failed in Congress. Congress rejected that effort. But then the president, Truman, just went ahead and did that anyway. And he said, we're going to take possession of the steel plants in order to keep the war effort going, and I'm going to invoke my war powers, my powers as commander-in-chief during a time of actual conflict in order to do this. And the Supreme Court said, well, wait a second here. The President of the United States has the job of enforcing the laws. And Justice Jackson set it out nicely in his concurring opinion, where he said, think of it kind of like a stoplight. Either you've got a green light where the Constitution specifically gives the president the power to do something, like to appoint the officers in the cabinet subject to the advice and consent of the Senate, or to name ambassadors subject to advice and consent. Those are clear delegations to the president to be able to do something. There you got a green light. And nobody can say, no, the president, you nominated the wrong person. That's not the best qualified person. That is totally within presidential power to decide that, okay? A red light would be something where a power is vested by the Constitution in another branch of the government. Take, for example, the power to declare war. That power is given to Congress. But let's say the president says, this is such an important matter, such an important foreign policy conflict, I'm going to take away from Congress the power to declare war, and I am going to declare war right now for the country. That's a red light. That would clearly be unconstitutional, and under Marbury versus Madison, the Supreme Court would have the power to revoke that. But then there's the yellow light situation, and this is where a particular power is not specifically enumerated either under Article 2 for the executive branch or under Article 1 for the legislative branch. And Congress has not said anything about it. It's neither delegated that power explicitly to the president, nor has it attempted to delegate that power to the president, but been thwarted in the effort to do so. And there's a yellow light situation, and that's where the court says it's very fact-based, intensive analysis. But the court said in the steel seizure case, this is an easy one, because there's nothing in the power of commander-in-chief that explicitly sets forth the power to seize steel mills or seize any instrument of the economy or commerce to keep things going. And Congress might have been able to delegate this to the president, to give him this power, but it did not do so. There was a bill put in to try to say the president has the power over steel mills and can open them up, but it chose not to do that. That becomes a red light. At that point, he essentially has been specifically foreclosed to undertake that action. All right, all of which is to say, the D.C. Circuit Court was very clear that this matter is indeed going to be up to the judiciary to decide. And in the course of finding that, the court cited this significant passage that has been absorbed into the bloodstream of America over the decades. It comes from a Supreme Court decision called U.S. versus Lee, in which the court wrote, "No man in this country is so high that he is above the law. No officer of the law may set that law at defiance with impunity. All the officers of the government, from the highest to the lowest, are creatures of the law and are bound to obey it. It is the only supreme power in our system of government, and every man who by accepting office participates in its functions is only the more strongly bound to submit to that supremacy and to observe the limitations which it imposes upon the exercise of the authority which it gives." In other words, in this passage, which has been recycled over the centuries, the Supreme Court is saying not only is it wrong that you as president somehow are not bound by the law, if anything, you are more bound by the law than everybody else. I like to say that those of us who aspire and attain to public office are nothing but the servants of the people, and the moment that we think we're somehow above the people and acting as kings and queens and lords and czars and emperors, that is the moment certainly to evict and eject and reject and impeach and convict and get rid of that person. And the Constitution gives us a lot of mechanisms to do so. All right, so now we're looking at the question. We know that the court is in the right place to be checking this out. Now we get into the heart of Donald Trump's claim, where he says, all right, you can hear my case, you're going to look at it, but I am categorically immune from any criminal prosecution. Why? And here's the argument. If you go to Article 1, Section 3, Clause 7, okay? And bear with me because it is an extremely tortured, pinched, and really comical reading of this judgment of impeachment clause. But what it says is this: judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted shall nevertheless, key word here, shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. Now, if you read that whole thing in context and give it a common sense read, it is certain to lead you to the conclusion that any president or former president can be subject to indictment, trial, judgment, and punishment. Now, if the president is also impeached first and removed from office by the Senate, and if the Senate decides to disqualify that person from holding an office again, still that convicted president can nevertheless be liable and subject to indictment and trial and judgment and punishment. And you could add in parentheses, because this is what the Constitution is really saying, just like all the other presidents, even though they haven't been impeached or convicted, but if they committed a crime, they can. But now, Trump's lawyers, somewhat cleverly, I must concede, flipped the entire thing upside down. And what they read it to mean is that only presidents who have been impeached and convicted can be subject to indictment, trial, judgment, and punishment. Now look at that for a second. They read it to say that basically, the only thing that can happen to you if you're impeached and convicted is removal from office and disqualification. But you also could be subject to indictment, trial, judgment, and punishment, but no other president could. Well, that's of course not what it says. It violates any common sense grammatical construction of the terms of it, and it is completely at odds with all other kinds of text within the Constitution, the structure of the Constitution, and the history of it. So let's start with this. It has always been assumed in our history that a former president could be criminally prosecuted for offenses undertaken in office that come to light later. Take the case of Richard Nixon, who we'll never know because he was pardoned, but who at least allegedly ordered a number of criminal acts, including the break-in at the Watergate, other kinds of criminal espionage, the taking of bribes, hush money, all kinds of stuff. And when he resigned from office, rather than face what would have been an almost certain impeachment and conviction, when he resigned, his vice president, Gerald Ford, became president, and the new President Ford pardoned him, gave him a pardon, because he did not want to see Richard Nixon being criminally prosecuted and having the country dragged through that. He said, but everybody assumed, from Gerald Ford to Richard Nixon to Congress to the country, that he could be prosecuted. The same thing happened with Bill Clinton, who actually entered into a plea bargain with the independent counsel in his case. Robert Ray was his name, who agreed not to bring charges against Clinton if Clinton would voluntarily resign from the bar for a 5-year period. And in order to avoid criminal prosecution, Bill Clinton entered into that agreement. Okay, so it's always been assumed that a former president could be criminally prosecuted. The D.C. Circuit says that it would create an extremely dangerous precedent to say that a former president cannot be prosecuted for crimes undertaken while in office, because that would be an invitation to do things like this. And this was asked aggressively of Trump's lawyers in the oral argument in D.C. Circuit. Could the president order assassination of his political rivals and opponents, pursuant to his power as commander-in-chief or some other power that he invokes? And the answer was yes, that the president could order a political assassination. But there was this check: he could be impeached and convicted. But if he were not impeached and convicted, Trump's lawyer said, then he could not be prosecuted. Now think about the implications of that for a second. It means the president could order his political party rival assassinated, and the vice president for the rival party assassinated, and their friends. And then if he's about to face impeachment, he could just go ahead and order the assassination of enough members of the opposite party, for example, to prevent him from being impeached or to prevent him from being convicted in the Senate. So as long as he can defeat impeachment and trial, then he can get away with assassination. I mean, come on. I mean, we are in la-la land at this point. And I think that's when Trump's lawyers lost even the Republican judge on the D.C. Circuit and really lost the interest of the country in this argument. So everybody can see what a dangerous proposition this is. It's especially dangerous in a case exactly like this, because Donald Trump's crimes were all directed at destroying the constitutional provisions governing succession in office. Look at the 20th Amendment. The Constitution is very clear about this. Your term of office as president and vice president ends at noon on the 20th day of January. It's over at that point. And the procedures for election of the president are set forth in the 12th Amendment, which the president has a constitutional obligation to execute and to defend and not to overthrow. And so everything Donald Trump did was a recipe for insurrection and rebellion. And I think as we looked at in our last class about the Second Amendment and insurrectionism, we have an anti-insurrection Constitution. There are half dozen provisions that are set up in the Constitution to block insurrection and political coups, and precisely the kind of thing that Donald Trump attempted to do on January 6, 2021. The DC Circuit called Donald Trump's efforts in those days an unprecedented assault on the structure of our government, and indeed it was. And if you think about it, rather than being protected by the separation of powers, which is what Donald Trump claims, his argument is a direct affront to the separation of powers. It would collapse the separation of powers. Why? Well, Congress sets forth in federal law what you can't do. For example, you cannot violate the voting rights of the people. You cannot interfere with a federal proceeding, although now that statute has been challenged in court in the Fisher case, and I hope we'll get a chance to talk about that at another point. But you, as president, cannot attempt to defraud the government of the United States as he did. Okay, so if the president is exempt from prosecution for violating clear federal laws, that denies Congress the ability to legislate. It also denies the executive branch itself the ability to prosecute, which is an executive branch function. And the president should be taking care that the laws are faithfully executed and presiding over the prosecution of violations of law, not thwarting them, especially when it relates to him. As Madison put it, nobody can be a judge in his own case. That's a cardinal principle of Anglo-American law. And similarly with the courts, if the president's absolutely immune from criminal prosecution for acts undertaken in office, well, then the courts are not able to take up an actual case or controversy and adjudicate the merits of them to determine whether or not a law has actually been violated. So the DC Circuit, I think, did a beautiful job of walking through the different parts of Trump's argument, which is kind of catch-can and all over the place, but exploits the fact that we don't have cases directly on point because, again, no president in our history has committed so many crimes in office and then gone on to claim absolute immunity from being prosecuted for them. And all of it comes back to the idea that we have a constitution that's put in place in order to hold people who have state power accountable to the rest of us. I mean, that's really what the rule of law is all about. People without power, people without wealth, have always been subject to the law. But what's different about the Constitution for a democratic society is the Constitution binds even people who have a lot of wealth and power. And that's really what the rule of law is all about. So we reject the fallacy that the commander-in-chief of the nation, who is not that, but that the president of the United States can do whatever he wants. We know that's not true. The job is to be bound by the law, to take care that laws are faithfully executed, not to trample the laws and violate them. And if the president does violate the laws, is subject not only to the impeachment clauses of the Constitution, but also to the criminal law and the civil law, including criminal prosecution for everything that he or she did when in office.
All right, so that was excellent. I've got some questions, but first, it's important to note that we're making this series to support Democracy Summer. So briefly, Congressman, can you explain what Democracy Summer is and how people can help?
Well, we're gathering right now hundreds and hundreds of high school kids and college kids across the country to come and get involved in democratic politics. We do seminars in the morning with the greatest historians and lawyers and elected officials and campaign tacticians and strategists and pollsters and you name it, over Zoom, and everybody will be participating together in seminars and discussion. I should say the kinds of seminars that we've been doing, Brian, are definitely a lot longer than the ones our people do. They talk for 5 or 10 minutes, and this is for the real constitutional nerds out there who want to get into this stuff in a deeper way. But the people go for 5, 10, 15, 20 minutes and then engage in dialogue with our Democracy Summer Fellows, with the young people. But then the key part is for the rest of the week, they're assigned to work with a Democratic campaign in their area. So they're going to be working for a member of Congress. It could be my friend Mike Levin out in California. It could be Maxwell Frost. It could be Mary Gay Scanlon in Pennsylvania. You name it, all over the place. But what we're trying to say here is that politics is all about education at its best. It's just about educating people about the Constitution, about the political system, and about the issues, and then how we are going to get together in order to make progress, for example, on restoring Roe versus Wade as the law of the land by passing a national federal law to give every woman the choice of whether or not to have an abortion. So we're going to explain how we're going to make progress once we elect concurrent Democratic majorities in the House and the Senate with a Democratic president in 2024.
And this is basically building the future of the Democratic Party. So if you want to help, if you know somebody who might be interested, definitely sign up. I'll put the link right here on the screen and also in the post description of this video. Okay, Congressman, first question here. If the Supreme Court rules that Trump does have immunity to commit criminal acts with impunity, does that then mean that Joe Biden has immunity to do the same? Like, I've heard people say, why wouldn't Joe Biden just cancel the election then, since there's no punishment for constitutional violations anyway?
Yeah, and this claim is so outlandish and freakish that it cannot survive even in this Supreme Court. They should have done the right thing and just summarily affirmed the D.C. Circuit Court opinion, which is magisterial, just denied cert. You know, cert is denied in 99% of the cases. Most cases that come up at the circuit level stop there, even when people try to appeal to the Supreme Court. So there would have been nothing strange about it. But in their wisdom, the Roberts Court decided to grant cert, which has tremendously slowed down the prosecution of United States of America versus Trump in Judge Chutkan's courtroom. So who knows where it goes? I mean, you know, at best they'll just imitate what the D.C. Circuit Court has done. At worst, they wait to the very last day. They wait till June, and then they remand it for findings about whether, you know, there was anything official about what he was doing, and create a different test for official versus unofficial acts versus acts on the perimeter in the gray zone or what have you. I mean, they can slice the bologna 1,000 different ways here in order to make it complicated for the trial to continue. And I think that's really the way they'll throw a monkey wrench into it. But the claims are so extreme that I don't think even this Trumpist court can go along with them.
Well, to the point you had just brought up, can you speak on the complicity of this Supreme Court to not only take up this absurd question in the first place, but to do it with such a gratuitous delay that would then only serve to push back Donald Trump's D.C. trial?
Yeah, I mean, don't get me wrong. The criminal courts in D.C. are on a time schedule that really shouldn't have anything to do with the elections. I mean, they can take it into account to make sure they're not too close to the election, which seems to be a pretty well-established kind of common law, you know, judicial principle. But basically, they're just following the normal law of the timing and scheduling of the conferences and the pretrial motions and the trials. It's the Supreme Court which is throwing a monkey wrench into the whole thing by needlessly taking up completely obvious questions like this one, and then making everybody wait several months before it's argued and before it's decided. And so we are pressing increasingly closer to the election. Of course, we're in right now, as we speak, Brian, another one of Trump's trials, which is his trial in New York by prosecutor Bragg for cooking the books, essentially, in order to engage in his hush money scheme to suppress facts from coming out before the election. So, like so many of Trump's cases, it's based on interference with the election and crimes committed along the way in order to withhold information, suppress information, try to get people to fraudulently count votes, create votes, or, in the case of Vice President Pence, trying to force people to go against the Constitution of the United States.
Just humor me on this one, because I think we all expect what the outcome of this case is going to be. But what would it mean if Trump is granted immunity if he were to win again in November? Like, what does a president completely unconstrained by the threat of prosecution for criminal behavior in the White House mean, practically speaking?
Well, I mean, this goes to the very heart of the American experiment. Like, the whole idea was we would become the first self-governing democratic nation in history, because the founders rebelled against centuries of kings and queens and merged church and state and autocrats and emperors and so on. The whole idea is the president would have the job of enforcing laws, not writing laws on a whim or trampling laws on a whim. The president would work for the people. The people would be in charge, would elect our representatives, and those representatives would write the laws, and the president would go and enforce the laws. And if there were confusion about who's supposed to be doing what or what the laws meant, the Supreme Court would have the power to enunciate what the law is. That's how the system works. But Trump wants to go back to a monarchical system. He wants to be a royal, where he can literally do anything. He can grab anybody by any body part that he wants. He can sexually assault people. He can steal other people's money. He can hire people and then not pay them their money. He can flagrantly violate the Foreign Emoluments Clause by taking millions of dollars in office from kings, princes, and foreign states. He's not bound by the law because he's the president, and there's no mechanism of accountability on his rendition by which you could hold him responsible for what he does do. So it basically is to vaporize the entire Constitution.
Trump has recently taken to claiming that a president wouldn't be able to get anything done if he didn't have immunity. What's your response to that?
Well, just look at our history. No other president has even thought to assert immunity or to operate on the basis that he's got categorical immunity for criminal offenses conducted in office. That's ridiculous. And he says, yes, if we get rid of this, then every president will be deterred from doing whatever he or she wants, and all they will do is spend their poor retirement of hundreds of thousands of dollars a year when they want to be playing golf unprosecuted and uninvestigated for crimes undertaken. But look, no president has ever been in this situation before. I guess Richard Nixon came closest, but Ford pardoned him. But no other president has dealt with this. And he says, well, if you don't allow me a get-out-of-jail-free card, then it will always be former presidents getting prosecuted by the next administration. It never happened before.
Right. I think the best one is him trying to kind of negotiate with Democrats by saying, if you take immunity away from me, then Joe Biden shouldn't get immunity either. And all of us are like, that's fine. He doesn't need immunity. That's the whole point. Presidents shouldn't enjoy immunity from criminal prosecution.
I mean, after spending a year and a half on the Oversight Committee as the ranking member and having seen all of the Republican evidence up close, I know that Joe Biden has nothing to worry about. They can't even identify a crime that they think he's committed.
Right, much less prove it to any degree. Congressman, can you speak on the difference between civil immunity and criminal immunity as it relates to a presidency? Because I think Trump is purposefully conflating the two in an effort to manipulate his base.
Generally, members of Congress and judges and the president, when they leave office, are civilly immune for official acts that they undertook while they were in office. Somebody doesn't like a law that the president signed into being or that members of Congress voted for, you can't sue them for having done that. Of course, there are some kinds of actions undertaken while you're in office that are not of an official nature. If you sexually harass somebody or sexually assault somebody and it's still within the statute of limitations, then you can be civilly sued for that. And this, I hope, will be the case which establishes that's the exact same thing for criminal prosecution as well. You are not going to be able to escape investigation and prosecution simply because you were president at the time.
All right, well, we'll leave it there. Congressman, what should we expect for the next episode of Class?
Well, look, we've been talking about the Emoluments Clause, so I thought now is the time to get into the Emoluments Clause and the specific fallacious claim that foreign governments and kings and princes can actually give you money, and you as the president can accept that money if you waive your federal salary or if you're willing to give what you deem to be the profits of such payments back to the U.S. government. We're going to look at those claims made by Donald Trump and his family, and we're going to unearth the history of the Emoluments Clauses and look at why they're in the Constitution.
And of course, to watch that episode, please make sure to subscribe to this channel. The link to subscribe and the link to support Democracy Summer are right here on the screen, and they're also in the post description of this video. I'm Brian Taylor Cohen.
And I'm Congressman JAMIE Raskin from Maryland's beautiful 8th Congressional District.
This is Class with JAMIE Raskin.